And we're back. And as you know, there is no substitution for reading. And I understand that many people are busy in their day-to-day life and only have the luxury and option of listening. So we're going to finish up this tutorial on objections. And this is the final conclusion. Now that you've finished this little book, you hold the golden key to success, to successful objections in court. You know how to make and respond effectively to most objections you'll encounter. You know the more common objections lawyers use. You know what they do. You know how to make them, and you know when to make them. We covered objections you are likely to encounter in a typical lawsuit. The total number of objections that could be made is limited only by the varied circumstances where the judge has or is about to allow something contrary to the essential requirements of justice. In all such circumstances, you must object. Effective objections will prevent what's about to happen if timely made and sustained by the judge. And notice the appellate court that you opposed what happened when it happened. Objections are like signposts along your lawsuit highway. They notify the court that you oppose something the other side has done contrary to the essential requirements of justice, and hopefully they stop the court from allowing it, or if the judge disagrees, your objection makes a record for the appellate court to see that something allowed should not have been allowed and did to it in a timely manner, thereby preserving your record for success on appeal if necessary. In both circumstances, your objections make a record showing you understand that the rules and demand that the rules be obeyed by your opponent and by the judge. Objections, if successful, prevent the court record from being polluted with facts that can fatally damage your case. Objections, if not successful, establish your right to be heard on appeal. Fail to object in a timely manner, and you lose your right to appeal. Objections, coupled with proper pleadings, proof, and procedure, lay a strong foundation for successful appeal and encourage the lower court judge to rule in your favor, rather than run the risk of being reprimanded by a higher court. Effective objections reduce the likelihood of appeal being necessary. Objections put the judge on notice you are preparing for appeal, that you recognize when errors are made, and that you won't sit idly by and let the judge permit those errors to pollute the record and damage your case. Objections let the judge know he must run his courtroom in accordance with the essential requirements of justice, due process of law, or be set straight by a panel of appellate justices whose duty is to ride herd on crooked and stupid judges. That may seem an overstatement, but it is the way things are. That's what objections do, and that's why we have appellate courts. You have just learned the more commonly encountered objections, but by no means have we covered all possible objections that may be raised in a lawsuit. The total number of possible objections is limited only by the number of errors, crooked deals, and corrupt practices one sees in a typical trial-level courtroom, where too often we find a theater for incompetence and legal chincery. American courts can only be controlled by those willing to abide by the rule of law and court and control their adversaries with a wise application of the principles and practices of American due process of law through timely objections that make a clear record for appeal. The foregoing gives you a starting point for understanding objections, but there's no substitute for practice. If there's a club near you, join and learn lawsuit practices and procedures with like-minded friends. Among the activities of the local club, you will share with friends practicing objections and other courtroom techniques as you learn the way of a winning lawsuit. Don't let the other side pollute the court record in your lawsuit with trickery and fraud that seeks to evade the rules unjustly. Control your judge and overcome crooked lawyers and deceitful opponents. Object and renew your objections when necessary to prevent them for appeal. To present them for appeal. This is how you win. As with everything we teach in our step-by-step course, you are encouraged to dig deeper by reading the decisions of controlling appellate courts that will more fully outline the details and parameters of these and other objections and legal doctrines. This little book, while certainly valuable to give you a grasp of the fundamentals, is no substitute for legal research that explores the principles and opinions that control the judges in your local jurisdiction. What you find will agree with what we have offered, but will go into much greater detail and, more importantly, will give you the power to control your judge by altering him or her to the controlling opinions of his higher courts. Never let the other side get away with anything that injures your case. Object, and when you object, be prepared to explain in detail with supporting appellate court opinions why your objection should be sustained. If the judge refuses to rule, move the court to rule, so your record is clear that his or her failure to rule was intentional, a clear judicial error that will be corrected on appeal. If failure to rule on your objection causes harmful error in your case, finally, if the judge overrules your objection or refuses to rule, be certain to renew your objection as explained in the foregoing pages. Object. By all means, object. But with all your objecting, be sure to preserve your objections for appeal. This is how you win lawsuits. That's the end of this book, ladies and gentlemen. I've got a series of about 20 books that are all roughly about 70 pages long that go into the basics and the fundamentals of lawsuits, objections, and into greater detail, intimate detail for those of you willing to take the time and learn. I'm going to go through each one of these books and make Facebook Lives. The videos may be 1 or 2 chapters a piece every time that I do it. I thank you for all your support with Self-Governance U. Without you guys, I wouldn't be able to do what I'm doing. If you want this literature for yourself, I warehouse it in the law library that I have on my Self-Governance U website. It's a $500 donation. Again, I'm not selling the private intellectual copywritten trademarked information in there. I am merely just a custodian, a librarian who maintains the library and continues to add to it. The literature, for all intents and purposes, within the library is free. You can find it on YouTube, Facebook, the internet. That's typically where we gathered all the information too. So if it's still out there and hasn't been whitewashed, if you're just looking for a great way to get a hold of this information, we already have it preserved for you. Maybe you're able to find this information. Then again, maybe you're not. If you're not, we have a place where you can go. And again, the donation is for a lifetime. So once you have it, it's yours. And then I'd encourage you to pay attention because I continue to add to that library time and time again with new credible details and information from present day cases that we currently get involved in or help other people with. So with that said, I'll let you guys go. And then when I come back on, I'm not sure which one we're going to get into next. Let's just see here. I've got a whole litany of them. Be heard, causes, defense, evidence, easy guide, forms, hiring, how to win, Islam, language, maxims, motions, natural, summary, the trial. So these are just a list of the books that are in the law library. These ones are actually out of the law Bible within the law library. So it's a zip file that has all these educational courses in it. Anyway, with that said, I'm going to dip out. I'll be back later. I hope this helped you out. Share it with your friends and your family. There's about, 5 or 6, 7 videos that we made over the last 24 hours that are all about objections and to help you guys out step by step on learning how to assert yourself in a court. If you find yourself in a court, again, I don't advocate that you go into a court. I don't advocate that you do what I do. It's dangerous, especially if you have a wife, offspring, and all these things, all these obligations. It's not wise for you to go in there and wear the armor of God, trying to go in there and assert yourself and make sure that justice is upheld. But nevertheless, it is wise for you to become educated and teach your offspring these things so they can stand upon sound doctrines, principles, and above all else, their rights. Because freedom is not free, so we encourage you to become knowledgeable so we can ensure that freedom exists for the next generation. Thanks for joining me, and we'll talk to you soon.